Welcome everybody. My name is Mitchell Zatto. I'm the Managing Principal at Charrock Pittman Legal, and thank you very much for joining us today for our webinar on closing leasing loopholes. When can a tenant turn an agreed non-retail lease into a retail lease? So we'll talk a bit more about that in a moment. But before we get started, I would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. I know many of you have attended our webinars before, so thank you very much for coming back again, and welcome back. And if it's your first time, then an especially warm welcome. We hope these webinars are just a helpful resource for you. It's an opportunity for us to share with you some of the things that we're seeing day to day in our practice that we think are good for people to know about and have some awareness of. And you can catch all the recordings of not only this presentation, but also our previous webinars on our website in the resources page. We've done webinars on pretty much all of the practice areas that we cover: commercial law, disputes, employment law, wills and estates, not-for-profit, and of course, many webinars on property law. And if you don't know much about who we are at Charrock Pittman Legal, we're a boutique firm. We have a lot of accredited specialists in these areas, so we're able to go into them in quite a lot of depth. But today we're looking at some recent developments in commercial leasing that we've been a part of recently. So I'm joined by Andre Ong, a principal here and an accredited specialist in property law, and Graham Egan, senior associate in a disputes and litigation team. And they'll be looking at today's topic, both from the lease drafting side, but also from the perspective of how these issues can unfold in disputes and in VCAT, which is where Graham particularly was recently involved in a successful outcome for one of our clients. So I know they're looking forward to getting into it and sharing their insights with everybody. But before we get in, just a couple of housekeeping items. As I mentioned, we are recording the session and it will be available on our website soon. If you have any, and we will let you know when that's available. If you have any questions, please feel free to type away in the Q&A box. We'll try to get to some questions as we go when the opportunity arises, but we'll also hopefully have some time for questions at the end. I'm conscious of everyone's time though, so if we do run out of time before the end of the hour, don't worry, we will keep track of questions and get back to you if we haven't been able to get to yours. And we'll also put our contact details back up at the end, so do feel free to get in touch with Andre or Graham afterwards. Before I hand over to Andre, just some fine print, we're lawyers after all, and needless to say, we can only give some general information in a webinar like this, and it is an area where obviously we've got landlords and tenants and different interests at play. So we're trying to address this in some general terms. Your circumstances will have a certain need to be looked at through a certain lens. So just keep that in mind as we're going through today's content. If any of it affects you or you think it could affect you, do get some individual advice on your own circumstances. And leasing legislation is state-based, so we're talking from a Victorian perspective. So that's all from me. I will hand over and welcome Andre, who will start taking you through today's content. Thank you, Andre.
Very much, Mitch. So for those of you who don't know me, my name's Andre Ong. I'm the head of the property team here and an accredited property law specialist. Just thought I'd go through a brief overview of what we're going to talk about today. Obviously, we're going to focus on our recent successful outcome in the case of Grandview Trading and SJV Properties. But, we thought we'd give a little bit of context to that. Where do we start? How did we get here? That basic distinction between retail and non-retail leases and the ultimate consumer test, which is, at this point in time, the very much the main test, or the only test really, in terms of determining whether something is going to be retail premises. How is that test then applied in terms of the nature of your permitted use, what's written into the lease, versus what the actual use is on the premises and how that has been interpreted over the years in a couple of key cases. That gives us a framework in terms of what are the key considerations when we're trying to work through whether something's retail or non-retail, especially if some of those things are in flux and where VCAT and the courts over the years have given a little bit of different weighting to different elements of it. And then that leads us nicely into what's changed and how we then get to the outcome of our recent case, which Graham Egan will take us through. And he's had that good, successful outcome there for our landlord client. That leads to a few practical implications of how, as landlords or tenants and agents, how you might want to consider both how you're undertaking your lease negotiations, but also what records you're keeping, what records you're wanting to maintain, how much you want to keep track of the actual use of the premises from commencement, but also importantly, leading into a renewal of the lease, because that's another critical point, and we'll run through why that's the case. Now, people's businesses do change over time, probably a little bit more quickly than was expected in our particular case, but there is then an issue of use creep. If there is a changing or evolving use of the premises and people start to lean more towards something that might meet the ultimate consumer test, how are you supposed to deal with that as landlord? What's the actual implication? And looking at it, post-renewal, leading into renewal, if there has been that kind of change of use, does that actually make you fall into or out of the act? Or is there an open argument there for a tenant to raise that they have fallen into or out of the act in that particular circumstance, which then leads to the natural conclusion of what are the litigation options then for a landlord or a tenant where that is the case, given there is a substantial commercial impact of whether you are covered by the Retail Leases Act or not. And then hopefully then we'll have some time for some Q&A to address each of any questions you might have or an individual scenario you might want to raise. Feel free to type it into the Q&A button chat panel if you like, and we'll try and get to them as we're going along. So the starting point, where do we start with all of this? Well, in terms of the Retail Leases Act, a retail lease is basically a lease for a retail premises, and a retail premises defined in the Retail Leases Act, Section 4, subsection 1 there, is premises that are used or are to be used wholly or predominantly for the sale or hire of goods by retail or the retail provision of services. Now, there are a bunch of exclusions and additional bits and pieces around those keywords, but those are the keywords. And for such a short string of words, they have created endless amounts of dispute and work for lawyers and issues for landlords and tenants over the years because of the extent of the protections that are in the Retail Leases Act, not least of which is the inability for a retail landlord to be able to claim land tax back from a retail tenant. So when you're trying to assess when something is retail or not, what is the test? Now, the courts have determined that to be the ultimate consumer test in a case called CB Cold Storage, which I'll go through in a little bit. But essentially, are the goods sold from or services provided on the premises provided by the tenant to the ultimate consumer of that good or service, being the person or entity who uses the goods or services themselves? So basically, is the good or service being consumed? Is it being converted into something by that end user? It doesn't matter anymore, and for a number of years, it doesn't matter whether that end user is another business or an individual or a member of the public. It is a very, very broad test, very much dependent upon the facts of a particular lease and its individual scenario. And the courts have gone multiple different ways in terms of interpreting how that would operate in individual circumstances. So even though that's a fairly concise way of setting out the ultimate consumer test, that is your starting point. But brass tacks wise, what does that actually mean? Because it's just the start of the journey, and that takes us to our next slide. So where you end up then is a series of cases where you may not necessarily think of these as retail, but these three cases are actually the underpinnings of how we've achieved the outcome that we've been able to achieve in the SJV Properties case that we'll go through in detail. So starting with CB Cold Storage, the permitted use there that I put in inverted commas, cold and cool storage, warehouse and transport facility. So nice and generic, nothing retail sounding about that whatsoever. But that is actually the case that has determined the ultimate consumer test as the key test in terms of identifying what is a retail use. And what the court has focused on in that scenario, because we're talking about a large-scale cold storage facility that was primarily used by supermarkets, so Coles and Woolies, driving large trucks in there with produce. But that premises was open to the public. It was available for use by customers of varying sizes who might consume those services. So just as Coles or Woolies could stick in a truck and large container loads of vegetables, so could Joe Farmer down the street or John Smith down the road, who might have just wanted to cold storage his own personal farming product. It's not necessarily the size that matters. It wasn't a business-to-business issue. Basically, the court focused on what was the actual end user and what was the service being provided. So you had storage services used by that end user that could be Coles or Woolies, but also any member of the public who decided to pay that fee and use the services of that business. And because of that, regardless of this being a large cold storage facility, it was found to be retail and able to access the protections of the Act. So, in some respects, an unexpected outcome there, but gives you very much a flavor of where the courts are looking at. They're looking at the principles of the circumstances of the ultimate consumer test applied to the actual circumstances of a premises and the actual use of a premises. That flows us on to the case of bulk powders and Sacon, where the permitted use was production, packaging, and storage of health supplements, not retail. And it included this extra line in it. By executing this lease, you acknowledge that your use of the premises is not predominantly retail and therefore does not invoke the Retail Leases Act. So the parties in that case have gone the extra mile. They've tried to really make sure that the place was non-retail, and that there's an active understanding between the parties that this premises could only be used for non-retail purposes. Basically, in that case, bulk powders was using the premises to manufacture supplements. Excuse me. To manufacture supplements, store them, and they were primarily engaging in online sales for those supplements. Now, the key thing there, though, is that as opposed to CB cold storage, VCAT focused on the extent of openness of the premises to the public. There was no signage. There were limitations to access. The tenant, as it turned out, had particular security concerns in terms of their industry. They were a little bit hiding where they were from their customer base unless they were very good customers of theirs. And the premises very much was focused on production and storage, with sales primarily being online and goods being shipped out of there. The key part of that case was really the extent of public access. So even though the tenant there was trying to argue that they were retail because they technically would have allowed people to come in and pick up goods from the premises, any of those people that came up to collect goods from the premises that they'd bought, as I said, would have had to fit into this category of being a good customer of theirs where there wasn't that broader security concern, and they were limiting the access of those people to just a small part of the premises. So that case helps to illustrate that there are limitations to what CB cold storage and that end user ultimate consumer test and how it applies, where that public access, that openness of the premises then becomes a more crucial element. That leads us on to a case of Verity and Richmond Footy Club, and this one is a win for Richmond Footy Club, where, as opposed to arguing over the actual permitted use, in this scenario, really the key question is, at what point can you fall into and out of the Act? Because in our particular situation, and Graham will go through in a bit more detail, but essentially there was arguably a change of mind from the tenants, and they started to argue that they were retail. And if that happens to you, when is the actual right point in time when a lease can fall into or out of the Act? So in Verity, the circumstances were, and as you may all know, a retail lease has to be one where the occupancy costs are under $1 million. If the occupancy costs exceed $1 million, you fall out of the act. In this case, basically the occupancy costs had changed over time and it exceeded the threshold, and the landlord was wanting to say that the footy club had fallen over the threshold, therefore they'd fallen out of the act during the term of the lease. But what the court had found is that this isn't a moment-by-moment assessment. There are key points in time that apply, as defined in the Act itself, as to when you assess whether something is subject to the Retail Leases Act or not. And once that's determined at that relevant point in time, which is basically at the commencement of the lease or at the renewal of a lease, once the status of a lease is determined at that point in time, it stays within that same status during the term, and it only falls in and out when it gets reassessed at the next point, which is either entry into a new lease or a renewal of the lease. So those three cases really set up the key issues that lead into where we're gonna run into some detail here with the SJV Properties case. So Mitch, if you can flip to the next slide. So it's really framing where we're starting. One of the key questions that we had to work through and to be able to convince VCAT on to be able to get a successful outcome. And what therefore has become more important in our view in being able to prove your case to say whether something's retail or non-retail. First one's being the importance of the predominance of use. Was it the full part of the premises? So was it the full premises, part of the premises? To what extent? Were there different purposes applied across the premises as there was in this case? And Graham will go through that in a little bit of detail. What was the intent of the parties? At the relevant point in time leading into the lease, what was the actual detail of the negotiation? What evidence did the parties have of the detail of that negotiation? Was it clear what was intended in terms of the application of the Act and the actual uses of different parts of the premises? Can you bring in that external evidence? Does the lease stand on its own, or can you bring in all of that negotiation that happened before that point to be able to illustrate what that intent was and therefore how the actual permitted use of the lease should be interpreted? Three, what's the relevant point in time again to consider when the Act applies? In this situation, we've had a tenant who is basically happy to proceed with a non-retail lease at point A and then entering into the lease, and then shortly thereafter decided that they were retail and trying to argue that point. But actually, is that open to them to do? And for those of you who are agents out there, I'm sure that's not the first time you've heard of that sort of scenario where someone's purported to change their mind to try to take advantage of the Act. So Graham will have some good things to say about this sort of scenario. Going forward, though, and one of the outcomes or collieries, I guess, that comes out of this case is there are additional risks that now arise because of this case, where at a point of renewal, if that nature of the permitted use of the premises has changed over time, then we've got to worry about, well, actually, is that a risk point? Is there going to be a change in the retail, non-retail use of that premises, whether it falls in the Act or not? And what do you need to do about it to make sure that you are, from landlord perspective or tenant perspective, retaining the type of characterization that you have originally bargained for? Ultimately, can the tenant change their mind to get themselves under the Act? So with that, I shall hand off to Graham, and he can run you through the details of SJV Properties.
Thanks, Andre. So in the context, everyone, of what Andre has been discussing so far, I want to take it a little bit further by focusing a little bit more narrowly on the recent decision in Grandview Trading versus SJV Properties, which is a case we were involved in. The current slide you're looking at has got the full citation, so if you want to look it up on Ostley, if you haven't seen the judgment yet, if you're struggling to find it, you can get in touch with us and we'll share a copy. It's an interesting decision that gives a lot of clarity to determining whether a lease is subject to the Retail Leases Act in circumstances where there is a retail component to the use. Often, as Andre was discussing, there's disputes over whether there is a retail use at all in the required sense. And that dispute draws you into the ultimate consumer test and so forth, which becomes very complex and nuanced. But sometimes, as in this case, it's agreed that there is, from the outset, it's agreed that there is a retail use to the premises. But determining that there's a retail use is really only the first half of the inquiry into whether the Act applies under Section 4. This decision talks to the next level of the inquiry, which asks whether that retail use is the whole or predominant use of the premises. What we want to share with you this morning is the approach taken by VCAT in this matter, which we believe really clarified the approach to that second inquiry and provides an interesting case study with some valuable lessons. I've got a bit of flu, so please forgive any sudden cough breaks, and bear in mind that half an hour really is never enough time for a litigator to unpack one of their matters. So I'll do my best with the available time to share some insights and some practical takeaways. But as Mitchell mentioned at the outset, always get in touch if you're unsure. Can we have the next slide? So if I can start with a bit of the background, the intention of the landlord in this matter was always for a commercial warehouse industrial use of the premises. The premises itself is situated in an industrial area. It's a large warehouse space, over 1,000 square meters of warehouse or factory floor space with a small office on the side. It's in a cul-de-sac. It's got no passing foot traffic. It's highly industrialized. There's no retail businesses operating from the surrounding properties as such. In addition, the warehouse itself inside has an internal crane for heavy lifting, and the unit is the front street-facing unit of 3, which shares a driveway with 2 similar industrial warehouses. So it's really not the ideal space to be running a retail operation from. And the landlord always intended to lease it as such. And so it was marketed from the outset as a warehouse, factory, and industrial space. Next slide. What happened, though, when it came to lease negotiations is that and I've given you the timeline here, on the 15th of February, the tenant put in an application to lease. In that application, the offer to lease specified the intended use as warehouse, manufacturing, importing, storage, and retail of stonework machinery and tools and portable houses. So the offer to lease mentioned all the intended components, but then added at the end retailing, because this tenant was in the business of stonework machinery and so forth. However, the first draft of the lease provided to the tenant didn't include any retail use because the landlord didn't intend to allow any retail use from the premises. However, the tenant came back and asked if it's possible to specifically include retail, and that initiated a process of negotiation. Andre was actually involved in that negotiation with the landlord, on behalf of the landlord with the tenant, explaining clearly the landlord's intention and not wanting retail. But the tenant pushed back and asked, is it possible to have some retail use and perhaps 50%? So not over 50%, not the whole thing, but some minor secondary use. That was reduced to writing, confirmed, and that ultimately led to the landlord agreeing to a lease which did allow for retail use, but under highly circumscribed conditions. We can go to the next slide. The tenant executed the lease on those terms, took occupation on 1 March, but from the outset refused to pay management fees and land tax, despite clearly being required to do so under the lease. In this slide, there are a couple of elements of the lease that I've highlighted there, and without reading through everything, I just want to highlight the fact that the parties expressly acknowledged that the premises would be subject to strict controls excluding the public, and that they acknowledged that at the commencement of their lease, this wasn't a retail lease. It wasn't predominantly or wholly used for retail purposes, and so it wasn't subject to the Act. But It seems the tenant either misunderstood or contradicted their agreed position from the outset. We go to the next slide. This led to a process of default on the payments. A default notice was issued, and in response, the tenant issued proceedings in VCAT, alleging that the lease was not subject to the Retail Leases Act and claiming relief. The tribunal framed the question as a preliminary question of whether the premises are retail premises within the meaning of that term as defined in the Act. Now, the spoiler alert, the tribunal ultimately found the premises were not retail premises. And I just want to unpack a little bit further the approach that the tribunal took, but it's important to highlight what I've just taken you through very briefly, that initial intention, that back and forth on the negotiation, the making of your intention very clear, recording it in writing, and then almost overemphasizing that agreement within the terms of the lease to make it very clear what's agreed. We can go on to the next slide. Andre's already taken you through section 4 in the test. I don't want to restate that, but I just want to highlight the underlines that what we're looking at here is whether under the terms of the lease, the premises are used or are to be used wholly or predominantly for a retail purpose. As we've discussed, there was an agreed retail purpose here, and that really leaves the question of whole or predominant use. We go to the next slide. Here, I just want to highlight that the tenant who brought the proceeding, their case wasn't based on evidence disputing what was in the lease or what was agreed. It wasn't based on evidence that they were actually using the premises a year into the lease for any retail purpose. The tenants relied on an intention to use the premises for retail purposes in future. Okay. And they didn't address at all the whole predominance aspect of it. Next slide. The tribunal's approach was essentially fourfold. It starts with the burden of proof, and that is the tenant as an applicant asserting that the lease did not apply, asserting the act did apply, had the onus to prove that it applied. Okay. The second element is the timing of that assessment. The tribunal correctly observed that whether the premises are retail premises is assessed at the start of the lease or at a renewal, not at a point a year into the lease, which is when this dispute eventually materialized before the tribunal. The question to be asked under section 4 is whether under the lease the premises are actually or intended to be predominantly or wholly used for a retail purpose. And the approach that was adopted is to start with the lease. Why? To ascertain the intention of the parties as at the start of the lease, because that's the point at which the inquiry is to be undertaken. And when there's no evidence before the tribunal of the actual use at the start of the lease, we look to the terms of the lease. Next slide, please. I want to quickly just take a step back to the case of Verity, which Andre mentioned earlier, and this is a really important case, which highlights that whether a lease qualifies as a retail lease and the act applies to that lease is only determined on commencement or renewal. If at commencement the act applies, it continues to apply throughout the term. However, a premises can fall out of operation of the lease, of the act. So it can cease to be a retail premises during the duration of the lease, and the act can stop applying. However, the act can't start applying during the term of the lease. That has to be reassessed at the point of renewal of the lease. And so there's really only, for whether the determining that the act applies is really only happening either at the commencement or a renewal. Next slide, please. A second important aspect highlighted by the decision is that of contracting out of the Act. The Retail Leasing Act expressly prohibits terms in a lease which exclude the operation of the Act. So a term which might say the Act will not apply to this lease, to that effect. Now, there's a distinction we have to draw here, which was relevant to this case and which the member unpacked in the VCAT hearing quite extensively. And that is the distinction between structuring your affairs and structuring your lease in such a way that it doesn't meet the requirements of the Act, and for that reason the Act doesn't apply, on the one hand. And on the other hand, true contracting out, which arises in a circumstance where your affairs and your relationship to each other does meet the requirements for the Act, but under your lease, you've excluded the operation. Now, in this case, the limitations placed on the use of the premises were designed to structure the affairs of the parties in such a way as to avoid the application of the Act. And that doesn't fall foul of the Retail Leases Act, and that doesn't amount to contracting out. Because at the end of the day, the parties have the contractual freedom to decide on what terms they enter into a lease and on what terms and how they conduct themselves in relation to that lease. But once that framework meets the threshold of Section 4, in that the premises are wholly or predominantly used for a retail purpose, then the Act applies. And then you can't contract out of that. If we can go to the next slide. It raises the question, in this case, about use creep, what we're terming use creep. As I've highlighted, in this case, what the tribunal was required to look at was whether at the commencement of the lease fell within Section 4 as a retail lease. In the absence of the evidence, the tribunal found that it didn't. And on the basis that the evidence relied upon by the tenant was that in future we will use this as for a whole or predominant, but wholly or predominantly as retail premises, that didn't serve to meet the threshold as at the commencement of the lease. And as Verity discusses and as Section 11 provides for, we only look at the commencement and the renewal of the lease. And so that raises the question, because you only have two on-ramps into the Act, and because the Act, although it might cease to apply midterm, it can't start applying midterm, what happens at renewal? You might enter into a commercial non-retail lease for a period of 4 or 5 years with an option to renew. And at the initial term, it's not a retail lease. You have circumscribed use requirements, which keep it outside the ambit of the Act. But with time and during the currency of the lease, and by the time you reach renewal, in fact, the facts have changed. And the tenant's use of the premises now bring it within the Act. And you're into the second term. And the question then arises for both parties as to the application as at the renewal of the lease, the application of the Act as at renewal of the lease. And that can have significant, as I'm going to chat about in a second, significant consequences for both parties. And that makes it really important to give careful consideration to what you include in your lease as at the commencement, and what you propose to include in any renewal of your lease, including a full analysis of whether the Act comes into operation in respect to the lease at that renewal. If we can go to the next slide. So let's talk practical implications here. Here's just a small scenario of what's at stake. If you have a standalone bulk warehouse, a commercial building with 3.5 million, with a site value of 2,750,000 owned by a Victorian resident. Your annual rent may be in the region of 140,000, and your land tax 27,500. Now, if the Retail Leasing Act applies and you're not entitled to pass on that land tax to your tenant. That was one of the primary disputes that arose in SJV and Grandview Trading, was the liability for land tax and the liability for management fees as an additional outgoing. When you add all this up, the outgoings that can be passed on to the tenant in a commercial lease, under a commercial lease versus what can be passed on under a retail lease, under the Retail Leases Act, is significant. And parties need to be able to plan their financial position accordingly. So it's important we have clarity from the outset. You can go to the next slide.
I might just add an extra comment there. Sorry, Mitch, if you can just get backwards a little. Just as a bit of a practical tip, in particular to the landlords and agents in the room on this sort of example, because it does link very much into that use creep scenario. You can't, unfortunately now, it's sort of the side effect of this SJV Properties case plus an extension of how Verity is applied in it. Because the key points of consideration are both commencement of the lease and the renewal, you can't blindly run through the renewal process without having that separate assessment of whether that use has crept up over the period of time. When, you might have started a lease where the predominant use was the non-retail and the smaller proportion was the retail, but over time that has changed and you get to the point of renewal and actually now the predominant use is the retail and the storage elements or the manufacturing elements have now shrunk. If you haven't properly considered that, you're exposing yourself in renewing the lease without thinking, in having just completed a market rent review on standard levels, assuming the lease was still going to be non-retail, and then a few months in, the tenant decides, well, actually, my uses had changed. It was retail at that point of commencement. And because you've already exercised the option, the market rent review is complete, your opportunity to have worked through a market rent review process, factoring in a prospective retail lease, is lost. So it is important to have that consideration of this issue, especially where you have multiple uses across a premises, to have that consideration of the issue going into that renewal and not just blindly going, okay, well, the tenant's got an option there. We've sent them their reminder notices to exercise, and we'll just deal with it that way. If you haven't thought through that prospective use creep, then you're exposing yourself to a risk. And similarly, from a tenant perspective, if there has been that use creep, it is something that unfortunately is open to be taken advantage of. And without that proper consideration, without that broader evidence of what was the intent between landlord and tenant on entry into renewal, you're not giving yourself as a landlord much ammunition to be able to defend that sort of attack, because that is a point of reassessment. The Act can commence applying at the point of renewal, even if it didn't apply at the point of the commencement of the original lease. So when you're talking about these kinds of dollars, when it could be a 20% differential on your actual return on the property, and more, because it's the land tax is always the thing that is the showstopper for people, but the Retail Leases Act does add a whole bunch of other obligations on a landlord that effectively adds more costs onto their bottom line. It's really important to consider at that point of renewal. So I just thought I'd make that point there, Graham, because your market rent review is really your point in time when you have a little bit more leverage to say, well, actually, tenant, if you're now a retail tenant, the market rent review is actually going to jump up to reflect that fact and to reflect the reality of the landlord still needing a fair return for their premises, but now incurring the land tax costs on their end. So I'll hand back to Graham.
Thanks, Andre, and absolutely correct. And just to follow on from that, two further observations is that as you highlight there, under the Act, there are a number of further obligations. We are talking about the financial. We're focusing in on the financial consequences because they are generally the source of disputes. But there are a number of other nuanced obligations that arise under the Act, such as disclosure and so forth, outgoing disclosure and consequential issues there that as a landlord you need to be aware of, and that as a tenant you're entitled to the protection of. And so there are points at the commencement and at the renewal of the lease that both parties need to make this assessment carefully, because if you're entitled to protection under the Act, you're entitled to protection. And the landlord needs to be aware of how they handle their side of the bargain as well. I also just want to highlight that you enter into a 5-year lease perhaps, and this raises its head as it did in this case early on in the lease, and it takes a year to resolve it. And as landlord, it resolves in favor of the landlord, which it did here. And so it's not subject to the Retail Leases Act. And we're in a 5-year lease. And we carry through that term of the 5-year lease on that basis, and there's a renewal. And at the stage of renewal, as Andre is highlighting, there's a need to reassess the position once again. And if that's not carefully and properly done, you risk landing in the same dispute in the second term. And so the question is, in a decade-long landlord-tenant relationship, how much of that time do we want to spend in disputes? The answer, of course, is none. And so that's why we're highlighting the importance of this analysis and the importance of clear lease terms at the appropriate times in order to avoid that. If we can just go to the next slide. And so the timing of your disputes matters. And there are 3 key stages: negotiation, commencement, and renewal. And we want to, without sort of encouraging disputes per se, we want to encourage parties to raise their concerns to each other at these 3 stages, and to give careful consideration to their position at each of these 3 stages, because at each stage, whether you're the landlord or the tenant, not gaining clarity and not reaching the agreement you intend to reach clearly in relation to the lease carries risk. We can go to the next slide. Now, practically, how do those risks manifest? And again, focusing on the financial obligations. If a landlord thinks they're entering into a commercial lease not subject to the Act, and that they'll be passing on land tax and further outgoings to the tenant, and the tenant raises a dispute early into the term, as happened in SJV, the landlord has to absorb those costs initially. Conversely, the tenant may feel that they are keeping land tax and outgoings at bay, but what's actually happening is that there is potentially a large single debt accumulating over the life of the dispute. And so that can, if the dispute doesn't resolve in favor of the tenant, that can result in a rather large once-off invoice of accumulated costs, which the landlord has had to absorb over the life of the dispute, which can be a year or more. And that, for both parties, creates a lot of financial strain and puts their budgeting in uncertain territory. In addition, the question of legal costs. It's important to have proper legal advice at the outset. And that's always money well spent, because it can go so far to avoiding disputes. But once you're in a dispute and legal costs are incurred, there are risks to recovery. In VCAT, where your retail leasing disputes are determined, it's generally a no-cost recovery with quite a high threshold for retail leasing specifically. So there's that additional financial element to consider. We can go to the next slide. A further aspect of the dispute resolution process in VCAT is that you generally head into a process of mediation, even before you get to VCAT and before the dispute blows up, because the Retail Leases Act requires parties first to go to the VSBC, the Victorian Small Business Commission, for dispute resolution, which will take the form of a mediation before initiating proceedings in VCAT. Now, a lot of parties we've seen will seek to avoid that process by asserting that it can't be resolved in mediation and asking for certificates so that they can get to VCAT. But what generally happens in VCAT is that VCAT is pushing matters to mediation by compulsory conference almost as a matter of course. And so the bottom line is you're likely to reach a stage of mediation. Now, mediation is a good opportunity for the parties to engage in the issues. But user beware that legal advice and even representation at mediation stage is advisable on these nuanced issues of whether the act applies or not. Because as you heard when Andre took you through the broader tests, it can get complicated. To jump back to Grandview Trading as an example, there was a mediation conducted within the VCAT structure, and parties thought the landlord certainly thought they'd reached a resolution on the issues. But what later transpired was that the tenant didn't see it as such. And so what can even arise in mediation is uncertainty and confusion as to the outcome and as to what is being agreed if you're not fully across the issues and what you're dealing with. We can go to the next slide. Couple of things about VCAT, and once you're there, all your retail leasing disputes are going to land up in VCAT. It's an accessible but complex forum. And so legal advice is key and understanding is key. We can do a whole separate webinar on the risks of self-representation in these forums. But it's important to note that there are particular nuances about whether the act applies, and that you need to be fully across that in order to successfully make or defend a claim in VCAT. Another element to consider about VCAT is that it is generally a no-cost jurisdiction, but there's an upside to that, which I'm going to get to. We can just go to the next slide. The upside of all of this, I see as we're running a bit short on time, is that a clear and structured agreement is so important. And reaching early agreement between parties as to whether the act is going to apply or not, and on what basis, is so important. And it's advisable for both parties to seek legal advice on that issue. Seek legal opinion on that issue, on their facts. Don't leave your facts to be determined by a VCAT member 2 years later. Get legal advice, independent legal advice early on. We want to stress as well that an agent plays a key role in this process, and an agent can take matters a long way to avoiding disputes down the line, because you may not have a solicitor involved and the parties may not want to go the route of seeking legal advice, and they rely heavily on their agents. And so there's quite a burden on the agent to highlight these red flags, to pick up on these red flags, and to push the parties towards engaging on what the exact nature of their lease is going to be. And just on that fourth block of reputational management, what we're saying there is that done well, whether by the agent or the advising solicitor, that works well. But when things go wrong, parties tend to look for where they went wrong. And so insofar as you play a role as an agent or as an advising solicitor, it's important to really give your time and attention to these matters and to encourage proper consideration, because at the end of the day, that's your role. We can go to the next slide. The solicitors will generally have quite a prescribed role. So if parties take their lease to a solicitor or ask a solicitor to be involved in the drafting and the consideration, there'll be generally quite a prescribed role for the solicitor, which we're always grateful for. But agents need to be a bit more conscious of their obligations under the Act and the regulations generally, because there often isn't a circumscribed or prescribed scenario put to the agent. The agent often has to pick up on the facts and the engagements between the party and their instructions from their client and the applications and engagement with the tenant and so forth, and will have to pick up on potential red flags and potential disputes so that we can avoid scenarios where the agent encourages the lease in one direction or the other on an incorrect fact set or an incorrect appreciation of the true scenario, because that just is where we head down this dispute route. We go to the next slide.
So
Andres,
I might just,
there.
sorry, I was going to jump in there as well, Graham. And I think actually, if you go back to the previous slide, Mitch, I might just take that opportunity to also give a shout out in that SJV Properties case to Chris McKenzie of Crabtrees, who was the agent who was acting for our client landlord as well in that scenario, because it was through Chris's records and our own in the course of that negotiation that helped support the outcome. And commercially, it was certainly a bit of a narrow pathway to run through and to negotiate, where the tenant did want that partial retail use, and there is that live issue of retail, non-retail. So Chris and I worked very closely together to get that particular outcome and to achieve that for the landlord. So I can only second all of Graham's thoughts there in terms of making sure that agents do proceed carefully in understanding those implications and not overstepping bounds, and making sure they're working closely with lawyers so that all the representations fit correctly. And if a tenant was to try something on, that we've got all of the right records and documents in place to support the landlord position, which I think Graham will go through a little bit more now in the next slide.
Thanks, Andre. And that actually segues nicely into the last slide. In that clarity at the start really prevents conflict later, but it also really helps resolve conflict later. And the point being that long before solicitors and litigation lawyers are involved in a matter, there is a factual scenario being played out between landlord and tenant and agent, and sometimes property lawyer. And it's so important to preserve and create a record of those negotiations and highlighting at key points the red flags. And to echo what Andre said, and just to is it wasn't really as highlighted in the decision's judgment, is that what we put forward quite extensive evidence from both Andre as the property lawyer and Chris as the agent as to how the negotiation towards this lease went and how the parties reached a point where they entered into a lease which allowed for the specific and circumscribed retail use. Because at all stages throughout those negotiations, the landlord's intention was made perfectly clear to the tenant. And that was conveyed and recorded in writing down to the point where it was included in the lease and acknowledged as such in the lease. And that creates the ideal setting to deal with any dispute that arises. And the same holds true for a tenant. A tenant that has a desire to include a retail component to the lease needs to make that clear. That's not something that you can or should be sneaking in after the fact or trying to grow through the term of the lease. That's something you should be making clear from the outset. And that's something that you should try and have included in the lease from the outset. Here, what transpired was that the tenant did, in fact, indicate they wanted a retail use allowance. And through those negotiations, the parties reached a point where they were in agreement that that could be allowed under certain terms and conditions and up to a certain proportion, given the landlord's intention and the nature of the premises. And so it's really important to document your intentions clearly and as early as possible, because when we're in the dispute 18 months into the lease, remember, we're going to come back and look at what was the position at the commencement of the lease. And so your contemporaneous records are really important, and preserving that negotiation history and preserving the correspondence. Sometimes it's not what was said, but also what wasn't said. So the full picture is very important. And then, of course, on these nuanced issues, seeking advice and aligning in your understanding. And, final thought then is, as lawyers and as agents, our role is to really, where we are involved, to help the parties with an understanding and to guide them in the right direction, and to put in that thorough consideration, because if we do it well at the commencement of the lease, things will continue to go well. That is all from me. I think we have some.
Yes, I think we've got a few questions there, Graham. I might just jump on to the first one from Ian Bellington. Do you have a lease provision that you utilize to ensure determining value is forced to consider the altered applicability of the Retail Leases Act on renewal? Now, the interesting thing with that is, yes, we have clauses that specify what valuers need to consider, but when something is subject to the Act, Section 37 of the Act actually lists out what valuers need to consider, including what outgoings the tenant is paying, and then a proper comparison of the premises to another premises of similar use, which in that situation would be another retail use. The difficulty there in trying to preempt whether something's retail or non-retail is that a valuer will not make that choice off their own bat. They will need to have direction in submission between the parties as to whether something is retail or non-retail, as to whether the valuer needs to use the set of factors that are determined in the lease alone in terms of assessing what is a market rent, or whether those factors are overridden to an extent by what's in the Retail Leases Act. So what I have found with valuers historically is if there's any dispute on those legal points applying to a matter, they will seek to appoint an external third-party independent lawyer to make that assessment and then make their determination on valuation using the appropriate set of factors, whether it's ones in the lease or the ones in the Act, based off that separate determination. So it isn't something that we can overly prescribe. Although if it's an issue of relevant risks that then could change applicability into the future, that could be something that's listed out in a bit more detail. But because if something's subject to the Act's own factors apply, it doesn't necessarily have to be detailed specifically to that scenario where if the Act applies, then this list, because the list of factors is already in the Act. Couple of interesting comments there, maybe to you, Graham. A VCAT case is always precedent-based.
Well, if I'm understanding the question correctly, is yes, in the sense that we do follow, even in VCAT, you follow the stare decisis doctrine, which says that higher courts and higher tribunals decisions should be followed by lower tribunals, and VCAT would be below the Supreme Court. Now, Verity, for example, was decided it started in VCAT and landed up in the Court of Appeal in the Supreme Court. And so that judgment would bind VCAT going forward. Generally, VCAT decisions wouldn't necessarily bind each other, but presiding officers will always look to create a uniformity of approach unless there's something obviously wrong with the prior decision. in VCAT. So to answer the question simply as I understand it, yes.
Yep, and then moving to the next one, is there a large difference between the various states' Retail Leases Act? The short answer to that, from my perspective, is they're all aimed at the same type of tenant protections. A lot of them have the same land tax limitation and greater obligations sitting on landlords. There are nuances and some greater clarity in other states in terms of what is and is not a retail lease. A lot of states have, for example, 1,000 square meter limit, where anything over 1,000 square meters is just automatically non-retail, which certainly is a helpful level of clarity in terms of whether the act should apply or not. So I can't say that Victoria is better or worse than the other states, but there is certainly different applicability across jurisdictions, and it is important when you're looking at leases in different jurisdictions, as I have through Queensland, New South Wales, ACT, South Australia, to look at the specific Retail Leases Act, Shop Leases Act. They're all called slightly different things, but to make sure that you've factored in whether the act actually applies in that state, because those threshold tests are not the same across the tests. The next question there is just whether on an option exercise, at the time of renewal, it was clearly non-retail, the options exercised. Is the landlord required to honour that exercise if there is that change of use and the tenant is now asserting retail? I take it before the lease has actually been renewed. So it's in that grey part, if you will, as you transition across into the renewal. And it is upon the entry into the renewal that you really have to assess the question. And there's an interesting nuance there in terms of whether there is a change of permitted use, because as you can see with a couple of different examples in the cases we've spoken about through this webinar, a lot of the permitted uses are very open-ended and a little bit vague in terms of whether they're retail or non-retail. So you can have something that isn't actually a change of use that ends up in that retail sphere just because the nature of the tenant's use of the premises might have changed over time. So say bulk powders is an example, they'd gone out of their way to try and prevent that public access, but say at the point of renewal, they'd completely changed their business model and now people were coming in every day and it was being used much more openly as a store that people shop at, as opposed to a place where online orders are filled and sent out. In that sort of scenario, it's a little bit more of an open-ended question as to whether you could say the option actually couldn't be recognised, because the permitted use allowed for that possibility that the tenant could open the place up and have people attend. So you need to be limiting, as a practical tip, you need to be limiting your permitted use to what you actually want to happen at that premises. If you have a strong intent for it as landlord to be non-retail and to have restricted public access to support that non-retail intent from both parties at the outset, write that into the lease. In that situation, if there is then a change and the tenant wants to have broader public access, etc., you have a greater right as landlord to just say no, because any change of permitted use is a variation of the lease. So that tells you that those permitted use clauses or supporting clauses linked to them need to have greater detail included to give you a bit more power in that sort of scenario. As we did in the SJV Properties case, there were provisions in there related to the extent of public access, related to the extent of the retail use, so that, and leading into the next period of time when this tenant, or if this tenant goes on to try to renew, that we have that control to say, well, hang on, if you're trying to expand this retail use now into more than half of this premises, and therefore we have a live risk that this is going to be determined to be a retail premises, that maybe we're going to say no to that because it's going to be a breach of the term. Or if we're going to say yes, then certainly market rent is going to be assessed at an entirely different level than it was agreed at the outset.
Thank you, Andre and Graham, for taking those questions, everyone. Thank you. We don't have time for any more, but do feel free to get in touch with Andre or Graham afterwards if you have any queries that you'd like to raise, I'll be happy to take a call or email. Just a reminder, this webinar will go up on our website soon. There are some examples there on your screen of other webinars that the team have done previously, which are there to watch. And the team are also publishing articles on about topics like today's and other things that are developing and emerging. So you can follow us on our social media channels to be alerted when new articles are published. We do have another property related webinar coming up next month in September, focusing this time on lifestyle villages and retirement homes, increasingly busy area, and there have been some developments in that area recently as well, particularly in relation to lifestyle villages and sort of sitting on the edge of the legislation and the requirements there. So if that's relevant for you, please do tune in for that. We'll send some more details around shortly. Finally, before I wrap up, just a quick plug for David Charrock's book, Fighting for Enterprise Success Through the Eye of the Tiger. It really is a really great resource for business owners and managers on various tools and strategies for developing a systems mindset and a success mindset in your enterprise. So we have a discount there, so do have a look at the website if you haven't seen the book before. I can highly commend that to you. So finally, again, thank you very much for joining us. Thank you, Andre. Thank you, Graham, for sharing your knowledge and experience through that recent case, but also more broadly. And we'll leave things there for now, everybody, but do get in touch if you have any queries. Otherwise, enjoy the rest of your day. Thank you very much.